Hello, and welcome to this diving discussion on one of the most controversial pieces of legislation introduced in recent times, that is, the Constitution 130th Amendment Bill 2025. This is Dr. Arjun Chowdhury, advocate. This bill has sparked unprecedented chaos in the parliament, with opposition members literally tearing up copies and throwing them at the Home Minister. But why? What makes this bill so contentious that it is being called draconian, unconstitutional, and even compared to an undeclared emergency? The bill proposes something that sounds reasonable on the surface, that is, removing ministers who are in custody for serious criminal charges. But beneath this seemingly moral objective lies a web of constitutional complexities that could fundamentally alter the balance of the power in Indian democracy. By the end of this video, you will understand exactly what this bill proposes, why legal experts are calling it a threat to democratic principles, and why this could be one of the most significant constitutional debates of our time. Let's understand the genesis of the crisis. On August 20, 2025, Union Home Minister Amit Shah introduced not one but three bills in the Lok Sabha that would forever change how we handle tainted ministers in India. The Constitution 130th Amendment Bill 2025, along with two companion bills for Union territories and Jammu and Kashmir, emerged from very specific high profile cases that embarrassed the government. The immediate trigger for this legislation was the case of former Delhi Chief Minister Arvind Kejriwal, when he was arrested in June 2024 in the liquor policy case. He refused to resign. For months, he continued as a chief minister while in Tihar jail, with his cabinet colleagues running the government on his behalf. Government sources reveal this was the moment they decided to bring this law, though they waited to avoid accusations of political vendetta. Another case that prompted action was Tamil Nadu Minister V. Senthil Balaji's case. Arrested by the Enforcement Directorate in June 2023 in a corruption case, he continued as a minister without portfolio for months. The Madras High Court even called this a constitutional travesty. Though he eventually resigned and was later reappointed after getting bail, the damage to constitutional morality was done. These cases highlighted a glaring gap in our constitutional framework. While the Representation of the People's Act 1951 disqualifies convicted legislators, there was no provision for ministers who refused to resign after arrest. This created situations where ministers could theoretically run governments from jail indefinitely. When Amit Shah rose to introduce the bill, opposition members erupted. They tore copies of the bill, threw papers at the Home Ministry, and forced multiple adjournments. The chaos was so intense that the Speaker had to suspend the proceedings. This was not just political theatre, it reflected genuine concerns about what many saw as an assault on democratic principles. So, what exactly does the bill propose? The Constitution 130th Amendment Bill 2025 seeks to amend three crucial articles of the Constitution. Article 75, dealing with the Union Council of Ministers, including the Prime Minister. Article 164, concerning state councils of ministers and chief ministers. Article 239 AA, special provisions for the National Capital Territory of Delhi. The bill introduces a simple but revolutionary mechanism. If any minister, whether Prime Minister, Chief Minister, or even an ordinary minister, is arrested and detained in custody for 30 consecutive days on charges punishable by 5 years or more imprisonment, they must be removed from the office. Here is how it would work. A minister is arrested and detained for serious offences carrying 5+ years of imprisonment. A 30-day clock starts ticking. By the 31st day, the Prime Minister for the Union Ministers or Chief Minister for the State Ministers must advise the President or Governor to remove the minister. If no advice is given by day 31, the minister automatically ceases to hold office. prime ministers and chief ministers must resign themselves by day 31 or automatically lose office. Importantly, the bill allows for reappointment once the minister is released from custody. This suggests the removal is temporary, based on practical inability to perform duties rather than permanent disqualification. The bill's reach is comprehensive, covering the Prime Minister and Union Ministers, the Chief Ministers and State Ministers, Ministers in Union Territories, special provisions for Delhi, Puducherry, and Jammu and Kashmir. Now the threshold question. Why 30 days? Critics argue this is arbitrary. The government has not provided a legal or constitutional basis for this specific time frame. It appears designed to align with standard judicial remand periods, but this makes the law seem tactical rather than principled. The bill applies to offences punishable with imprisonment for 5 years or more. This covers corruption and money laundering, major financial crimes, serious criminal offences, many offences under the special laws like the PMLA. The bill provides no safeguards against misuse. There is no judicial review mechanism, no appeal process, and no protection against arbitrary detention. The decision to arrest and detain rests entirely with the investigating agencies, which critics argue are not neutral bodies. The bill raises serious questions about fundamental constitutional principles. Article 14, that is right to equality. The bill creates an unequal treatment between legislators and ministers. While MLAs and MPs are disqualified only upon conviction, ministers face removal merely upon detention. This creates a two-tier system that may violate the equality principle. Next comes Article 19, that is freedom of speech and expression. By removing elected representatives from office without conviction, the bill may infringe on their right to participate in democratic processes and represent their constituency. Article 21, right to life and personal liberty. Most critically, the bill violates the due process component of Article 21. It punishes individuals without trial, conviction, or even charges being formally framed. Innocent until proven guilty is a cornerstone of our legal system. The bill fundamentally reverses this by treating detention as sufficient for punishment. This represents a seismic shift from conviction-based disqualification to arrest-based removal. The bill disrupts the constitutional balance between the three organs of government. It gives investigating agencies unprecedented power over elected officials. It circumvents the court's role in determining guilt or innocence. It can disable elected governments without legislative process. India's federal structure is based on the principle that states have autonomy in their internal affairs. This bill allows central agencies to effectively destabilize state governments by arresting chief ministers or key ministers. This represents a fundamental attack on federalism. Legal experts argue this bill violates the basic structure of the constitution established in the Kesavananda Bharati case. The basic structure includes democracy and democratic processes, federal structure, separation of powers, rule of law, and judicial review. This bill potentially violates all these principles. The Supreme Court has consistently held that the constitutional morality must prevail over popular morality. While the bill claims to uphold constitutional morality by removing tainted ministers, it actually violates deeper constitutional principles of due process and presumption of innocence. If chief ministers continue to be arrested and automatically removed, it could trigger more frequent use of Article 356. This could lead to the collapse of federal democracy and increase central control over states. This bill requires a special majority in both houses of the parliament, that is, two-thirds of members present and voting, and more than 50% of total membership. Given the NDA's current numbers, this is mathematically challenging without opposition support. The most damning criticism of the bill is that it reverses centuries of legal tradition. Instead of innocent until proven guilty, it creates a system of detained equals guilty. The presumption of innocence has deep roots in English common law and is enshrined in international human rights instruments. India inherited this principle from the British legal system, and it's fundamental to our criminal justice system. In numerous cases, the Supreme Court has emphasized that arrest does not imply guilt. Charges don't constitute conviction. Detention is for investigation, not punishment. The Manoj Narula case specifically held that there is no bar on appointing persons with criminal charges as ministers, though it emphasized moral responsibility. Supporters argue that ministers hold positions of constitutional trust and must maintain higher standards. However, critics counter that this trust is given by the people through elections, not by investigating agencies through arrests. Most democratic countries follow conviction based disqualification. This bill would place India in the company of authoritarian regimes that punish political opponents through arbitrary detention. If we accept detention as grounds for removal, where does it stop? Could preventive detention laws be used to remove political opponents? Could protest arrest lead to automatic disqualification? This bill could lead to busier situations. A chief minister arrested during a peaceful protest automatically loses office. Ministers could be detained by central agencies to destabilize state governments. Bail and re-arrest cycles could be used to manipulate political outcomes. By bypassing judicial determination of guilt, the bill reduces courts to mere bail granting authorities. It undermines the judiciary's constitutional role as the final arbiter of legal disputes. The opposition's reaction was unprecedented in its intensity. Multiple parties united in their criticism. The position of the Indian National Congress is that it called the bill draconian and an attack on the democracy. Priyanka Gandhi Vadra termed it an assault on individual freedom, raised concerns about weaponization of central agencies. Regional parties were also vocal and have protested severely against the introduction of the said bill. Trinamool Congress called it as a more than a super emergency. AIMIM said final nail in the coffin of elected governments, and the Aam Aadmi Party has also said clear targeting after Kejriwal's case. Legal scholars across the spectrum have raised serious concerns. M.A. Baby, former minister and constitutional expert, calls it an attack on India's constitutional architecture, warns of weaponization against opposition parties, highlights violation of Article 14, 19 and Article 21. Sanjay Hegde, senior advocate, warns that police officers could become bosses of ministers, highlights the dangerous precedent of executive over elected representatives, emphasizes the violation of innocent until proven guilty. Law schools and constitutional experts have pointed out conflict with existing legal precedents, violation of international human rights standards, threat to democratic governance, potential for political misuse. Opposition rule states see this as a direct attack on their autonomy. Central agencies primarily target opposition leaders. 95% of ED and CBI cases since 2014 involve opposition politicians. State governments lose control over their own ministers. The bill was introduced just before the monsoon session ended, with immediate referral to a joint parliamentary committee. Critics argue this shows the government doesn't expect to pass it easily and is using it for political optics. Democracy watchdogs and international observers have expressed concerns about erosion of democratic norms, weaponization of law enforcement, concentration of power in the hands of the executive. Opposition parties argue this could affect electoral outcomes. Voters' choices could be nullified by arrests. Democratic mandates could be overturned by agencies. Election campaigns could be disrupted by strategic arrests. The bill's most dangerous aspect is its potential weaponization through central investigating agencies. Data reveals a concerning pattern. Since 2014, 95% of cases by the central agencies target opposition leaders. Under UPA, that is 2004 to 2014, only 54% targeted opposition. 121 prominent politicians investigated since 2014 with 115 from the opposition. Central agencies have developed a pattern: arrest high profile opposition leaders, deny bail repeatedly, keep them in custody for extended periods, sometimes drop cases after political objectives are met. Arrests often coincide with important elections, parliamentary sessions, political crises, coalition negotiations. Ironically, when Congress MP K.C. Venugopal reminded the House that Amit Shah himself was arrested in 2010 in the Sohrabuddin encounter case, Shah responded that he had resigned on moral grounds before arrest. This raises questions about selective application of moral standards. The bill provides a constitutional mechanism to destabilize opposition governments, arrest key ministers or even chief ministers, keep them in custody for 30 plus days. Automatic removal creates political crisis. Possible imposition of precedents rule. In coalition governments, removing even one or two ministers could tip the balance of power, force floor tests, lead to government collapse, trigger fresh elections. Courts have repeatedly warned against agency misuse, called ED and CBI caged parrots, criticized arbitrary arrests, highlighted pattern of targeting opposition, demanded accountability and even transparency. Similar laws in other countries have been misused. Turkey used to remove opposition mayors, Hungary targeting civil society leaders, Venezuela systematic harassment of opposition. Some analysts suggest the bill is insurance for the ruling party, protects against future losses, ensures control even in opposition, maintains leverage over political opponents. Senior advocates and constitutional law experts have identified multiple legal flaws in the said proposed bill. The bill violates the due process clause derived from Article 21. Removing someone from office without judicial determination of guilt violates fundamental fairness. Creating different standards for legislators versus ministers violate Article 14's equality guarantee. No opportunity for defense, explanation, or appeal violates principles of natural justice. Key Supreme Court judgments that are in conflict with the bill. Lily Thomas case established that disqualification requires conviction, not mere charges. In Manoj Narula case, the Honorable Supreme Court had held that appointment of persons with criminal charges as ministers is not constitutionally barred, emphasizing moral rather than legal compulsion. The basic structure doctrine protects core constitutional principles from amendment. The bill has been referred to a 31-member joint parliamentary committee comprising 21 members from Lok Sabha, 10 members from Rajya Sabha, representation proportional to party strength. The committee has been asked to examine the bill in detail, consult stakeholders and experts, hear public opinions, submit report by the first week of next session. The committee must address constitutional validity concerns, safeguards against misuse, alternative mechanisms, international best practices, impact on federal structure. Now, let us discuss the expected legal challenges. If passed, the bill will likely face Supreme Court challenges under Article 32, questions of basic structure violation, petitions from affected parties, and constitutional validity tests. The bill faces significant hurdles: no two-third majority for the NDA, united opposition resistance, state government concerns, and civil society opposition. For passage, the bill needs two-thirds majority in both houses, more than 50% of the total membership, possible state ratification if affects federal structure. So the possible outcomes include withdrawal due to opposition, significant amendments and safeguards, passage with sunset clauses, complete rejection by the parliament. The Constitution 130th Amendment Bill 2025 represents more than just a law about tainted ministers. It is a fundamental question about the nature of Indian democracy. Do we trust elected representatives or investigating agencies? Should detention equal disqualification? Can constitutional morality override due process? Is this reform or regression? This bill presents a classic democratic dilemma, balancing the need for clean governance with protecting democratic rights. While nobody supports corruption, the means proposed may be worse than the problem they seek to solve. If passed, this bill could precipitate a constitutional crisis, mass challenges in courts, federal center conflicts, international criticism, democratic backsliding concern. India's global image as the mother of democracy is at stake. International observers are watching closely to see whether India maintains its democratic credentials or slides towards authoritarianism. The emergency of 1975 to 77 taught us the dangers of constitutional overreach. This bill, while not imposing emergency, creates mechanisms that could achieve similar results through seemingly legal means. This is a moment that demands public awareness and debate, civil society mobilization, media scrutiny, academic discourse, and international attention. As we conclude, remember that constitutions are not just legal documents, they are the soul of a nation. Every generation must decide whether to strengthen or weaken democratic institutions. The choice we make on this bill will define India's democratic future for generations to come. As informed citizens, you have a role to play. Understand the issues, engage in democratic discourse, hold representatives accountable, protect constitutional values, ensure your voice is heard. This bill is not just about tainted ministers. It is about the kind of democracy we want to leave for our children. The choice is ours and the time to act is now. Thank you for joining me on this deep dive into one of the most controversial constitutional issues of our time. Democracy works best when citizens are informed and engaged. Keep questioning, keep learning, and remember, in a democracy, the price of freedom is eternal vigilance. Until next time, this is Dr. Arjun Chowdhury, advocate, reminding you that knowledge is power and constitutional literacy is the foundation of democratic citizenship. Jai Hind.